2. Insurance policy provisions. When a life insurance company enters into a contract of insurance, it issues a policy. The policy and all amendments are generally also referred to as the insurance contract. Life insurance policies can be lengthy legal documents, but they have certain characteristics which are common to most. It should be noted that individual insurance, group insurance, and accident and sickness insurance 91 have many similar but slightly different statutory provisions governing them. The first part of this chapter will briefly describe these components: black small square parties to an individual policy, black small square formation of the policy, black small square term and termination of policy, black small square assignment of a policy. The second part of the chapter will review the specific provisions of the following forms of life insurance: black small square individual life insurance, black small square group life insurance, black small square accident and sickness insurance. Other kinds of policies or products marketed by life insurance companies legally qualify as life insurance, but do not resemble traditional life insurance policies: black small square annuities, black small square segregated funds, individual variable insurance policy, IVIC, black small square registered retirement products, black small square pension products. A key point to be made, from a legal perspective, in relation to these specialty products, is that they are subject to special regulation, and that the contract terms and conditions must meet regulatory requirements to qualify for preferred tax treatment. 2.1 Parties to an individual policy. Individual life insurance contracts are entered into between the following parties: black small square insurer, black small square policyholder, also known as the insured. A life insurance policy is simply the contract between an insurer, insurance company, and the policyholder. Depending on the type of insurance, there may be other persons referenced or involved in and/or deriving rights thereunder, such as the life insured, the beneficiary, a contingent beneficiary, a successor owner, or an assignee. These will be discussed more fully below. 2.1.1 Insurer. The insurer is the life insurance company that takes on the risk and issues the policy. The insurer actually responsible for the policy may change over the years because of corporate purchases and amalgamations between insurers or acquisitions of their books of business. The rights and obligations under a policy are assigned to and assumed by the new insurer. Acquiring insurers who assume the obligations of the former insurer are required by regulators to issue certificates of assumption to affected policyholders. The terms of the policy continues to be binding on the parties to it and persons claiming under them. 2.1.2 Policyholder. The policyholder is the individual or legal person, example, corporation, who has legal ownership of the policy and exercises the contractual and statutory rights that go with being the owner. The first policyholder is the one that forms the original contract with the insurer. In summary, the person who makes the contract with the insurer is the insured or policyholder or owner and is a party to the policy with contractual rights. 92. The policyholder can also be the life insured, owning insurance on their own life, but it is common for the policyholder to own insurance on the life of someone else, such as a spouse, child, or parent. There can also be more than one policyholder. There may be co-owners of a policy. Thelma and Arthur are spouses. They co-own a policy on both their lives, which will pay the death benefit when the second life insured dies. Example 2. Elliot and Alice are siblings. After a meeting with their father and their agent, they have opted to own and pay for an annuity policy with their father as beneficiary. This annuity provides for the care and financial needs of their father, who retired with limited income. This ensures that as siblings, they will both have access to policy information, and that any beneficiary changes to the policy must be approved and signed jointly. Two policyholders may also own different portions of a policy. Example: Roger owns ABC Bikes Incorporated, a cycling equipment company. The company needs financial protection against the death of Roger, who is a key person in its operations. Roger purchases insurance on his life and assigns the ownership of the death benefit to the company. Roger retains ownership of the savings and investment component, where he will be able to shelter personal investment capital for retirement. The company and Roger divide the cost of the insurance on a reasonable basis, with the help of their accountant. Co-owners of a policy may enter into their own private agreement that is separate from the insurance policy. The shared ownership agreement can set out their rights and responsibilities, including what happens to the insurance policy when one of the co-owners dies. 2.1.2.1 Successor policyholder. If the policyholder is not also the life insured, the policyholder could die before the insured person, i.e., while the insurance is still in effect. Ownership of the policy will then be transferred to a new owner. The identity of the new owner can be determined in advance by the policyholder. 90. This can be done in the policy or by an amendment. The person identified to become the owner when the policyholder dies is called the successor policyholder, sometimes called the contingent policyholder, successor owner, or subrogated owner. If the policyholder has not named a successor policyholder, then the new owner will be his estate, and therefore indirectly his estate beneficiaries. This may not be what the policyholder intended. Example: Roger owns a policy on his own life and one on the life of his common-law spouse, Susan. Roger wants ownership of the policy on Susan to pass to her if he dies first, and not to his children, so he appoints Susan as the successor owner by an amendment to his policy. While Susan is not a party to the policy during Roger's life, after his death Susan will acquire all of the rights and privileges that Roger had under the policy. 2.1.3 Life insured. The life insured means the person whose life is insured and on whose death the benefit is paid, also called the person insured or insured person. It is common that the lives of several individuals are insured under one policy. For life insurance to be valid at issue, the policyholder must have an insurable interest in the life of the life insured. 94. 2.1 For beneficiary. A beneficiary is a person to whom, or for whose benefit insurance money is payable. The ability to designate a beneficiary by contract or a written declaration is enabled by the provincial or territorial insurance statutes. 95 Most insurers now also accepts electronic beneficiary designations. 96 Beneficiaries have rights under the insurance policy, but are not a party to it. They may be named as a beneficiary at the time the application is completed, but they may or may not be mentioned in the policy itself. The policy may say that the beneficiary is the person you named in the application. For this policy, the rules which apply to beneficiary designations are invariable, and as such the type of benefit is irrelevant in determining the validity or effect of a beneficiary designation. If several beneficiary designations have been made, and there is confusion as to who is rightfully entitled to the benefit, agents should not hesitate to invite clients or their representatives to obtain legal advice to ensure that their rights are protected and that the payment of the benefit is executed in accordance with the policyholder's intent. Designating certain individuals as beneficiaries of a policy cannot only protect death benefits, it can protect the policy itself from execution and seizure. In this context, execution is the action of enforcing a judgment. These certain individuals are commonly known as protected or family class beneficiaries. These preferred beneficiaries are the following: Black small square spouse, including the common law spouse. Black small square child. Black small square grandchild. Black small square parent of the life insured. The policyholder may also later name or change a beneficiary using a beneficiary designation or change form issued by the insurer, unless the existing designation is irrevocable. 97 Since beneficiary designations must be in writing, they may also be found in other written documents such as a will, or other documents prepared and signed by the policyholder. Point 98. If the designation is revocable, a different beneficiary, including another protected class beneficiary, can be named without the beneficiary's permission. However, there may be restrictions on a policyholder changing beneficiary designations, such as a separation agreement, or even a court order, despite the fact that the designation is shown on the records of the insurer as revocable. It is important for agents to be aware that insurers will pay benefits based on the most recent beneficiary designation they have on file, or to the estate in accordance with the most recent will or estate document filed with the insurer if there is no beneficiary designation. Insurers making such payments are protected by law when doing so, and are not liable if another beneficiary designation or will exists, and they have not been made aware of it. Agents need to be aware so they can properly advise the insured. 2.1.4.1 Irrevocable beneficiary designations. A policyholder may agree to make a designation irrevocable. Such a declaration must be filed with the head office of the insurer in order to become irrevocable. If not filed, it remains a revocable designation. Point 99. If the policyholder names a beneficiary as an irrevocable beneficiary, then they can only change, revoke, that designation if the irrevocable beneficiary consents to the change. They must also get the consent of the beneficiary to withdraw policy cash, pledge or assign the policy, take policy loans, or surrender the policy. Point 100. In Nova Scotia, to make a valid irrevocable beneficiary designation, the irrevocable beneficiary designation must contain, attached to the policy, the following declaration signed by the insured. 101. I understand that the effect of my designating a beneficiary irrevocably is that, under the provisions of the Insurance Act, while the beneficiary is living, I may not alter or revoke the designation without the consent of the beneficiary, and I may not assign, exercise rights under or in respect of, surrender or otherwise deal with the contract without the consent of the beneficiary. It must also contain the following declaration signed by the agent. I certify that I have fully explained to the insured the nature and effect of making an irrevocable designation of beneficiary, and such explanation was given to the insured not in the presence of the beneficiary, and that the insured indicated that he was aware of the irrevocable nature of the designation so made by him. Example: Robert and Edna separated and signed a separation agreement, which included a promise by Robert to make and keep Edna as beneficiary of his life insurance policy until he no longer had to pay her child support. To reduce the chances of this not happening, Edna's lawyer asked to have Robert sign a change of beneficiary form making Edna the irrevocable beneficiary of his policy. The lawyer then sent the signed form to the insurer head office and asked them to acknowledge receipt, thereby putting the irrevocable nature of the designation into effect. The designation of an irrevocable beneficiary, even though not of the preferred beneficiary class, also renders the policy exempt from execution of judgment and seizure. Point 102. 2.1.4.2 Restriction in legislative definition of beneficiary. It is important to note that the term beneficiary, as contained in provincial insurance legislation, has a restricted meaning for some legal purposes. For example, the different insurance acts define beneficiary as a person other than the insured or the insured's personal representative to whom or for whose benefit insurance money is made payable in a policy or by a declaration. 103. Policyholders may also choose to designate their estate as the recipient of the insurance benefits. This is the subject of the second part of the restricted definition of beneficiary. The personal representative referred to in the definition is the executor or estate trustee, and they do not meet the statutory definition of beneficiary of the insurance. Proceeds payable to the estate 104 would be collected by the executor and distributed according to the policyholder's will or the relevant provincial law if the policyholder was intestate. Example: Ted owns a policy on the life of his wife Laura and has named himself as the beneficiary. Ted is the policyholder, i.e., the person who entered into the policy with the insurer. Ted therefore does not qualify as a beneficiary under the statutory definition. He will still receive the insurance money if Laura dies. If Laura owned the policy on her life, so that she was both the insured, as well as the life insured, and she named Ted as her beneficiary, he would qualify as a beneficiary under the legislative definition. Meeting the statutory definition of beneficiary could be very important in determining the protection the policy would enjoy from creditors during life insured's lifetime, and the protection the proceeds might enjoy upon her death. Policyholders who do not qualify under the legislative definition of beneficiary receive the insurance money in their capacity as owner of the policy. 105. In the common law jurisdictions, it is the relationship between the life insured and the beneficiary, not between the policyholder and beneficiary, which is crucial to creating creditor protection. 106 In the case of the death of the life insured under the policy, for the death benefits not to be paid through the estate of the policyholder and his creditors, as the case may be, the death benefits must be payable to a beneficiary. The policyholder or his estate does not qualify as a beneficiary under the relevant Insurance Act. 107. The following example illustrates how these provisions might operate to protect the insurance proceeds and the policy. Example: Rick purchases a policy on his own life. He is both the policyholder and life insured. He designates his spouse Renee as the beneficiary. She qualifies as a beneficiary under the statutory definition, since she is not the policyholder. The proceeds are therefore presumed to be protected from the creditors of Rick's estate. In addition, since Renee is the spouse of the life insured Rick, Renee is also within the protected class of beneficiaries. Accordingly, the rights and interests of Rick in the contract itself during his lifetime are also exempt from execution or seizure. 2.1.4.3 Loss of protection. The designation of a beneficiary, including a protected class beneficiary, is subject to being set aside and ignored if it is made in an attempt to defeat, delay, or hinder creditors. This is an aspect of bankruptcy and insolvency law and fraudulent conveyances, and beyond the scope of this chapter. The important principle is that designations that are made in an attempt to defeat creditors may be subject to challenge, despite the insurance provisions. The same would apply to the purchase of a life annuity or segregated funds, which qualifies as life insurance and could otherwise normally be protected. Rick owns a life policy with a very large cash value payable to his estate. He learns that a lawsuit from a business supplier has gone against him, and the creditor is about to obtain a judgment against him, so he designates his son Roger as a beneficiary. Roger is within the protected family class of beneficiaries, but the timing of Rick's action shows it was intended to frustrate his supplier's claim. Therefore, the designation may be subject to challenge. 2.1.4. For contingent beneficiary. It is also possible to name a contingent, also called secondary beneficiary, to address the possibility that the primary beneficiary might die before the life insured. If there are multiple beneficiaries, primary or contingent, and one or more die before the life insured, the policy provisions, beneficiary designation form provisions, also part of the policy, or statutory provisions 108 in default of policy provisions, may determine how the proceeds are redistributed. If there is no valid primary or contingent beneficiary designation in effect on the death of the life insured, the insurance proceeds will be paid to the current policyholder or to its estate if the policyholder dies after the primary and contingent beneficiary. 2.1.5 Group insurance policies. Insurance companies also offer group insurance policies, insuring the lives or health of a defined pool of individuals, and often their spouses and dependents, under one policy. The pool usually consists of employees or members of a group such as a union or association with a clearly definable and controlled membership. 2.1.5.1 Plan sponsor. Group plans are arranged by a plan sponsor. The sponsor may be the employer or a union or professional association or some other entity representing the group. It is the sponsor, called the group insured, or group policyholder, who enters into the master contract/policy with the insurer. In accordance with normal contract law, it is therefore the group policyholder who determines through the policy provisions what the insurance benefits will be for members of the group. 109. 2.1.5.2 Insurer. The life insurance company providing group insurance benefits does not have a contract with each individual member of the group. Instead, as mentioned, they contract with the plan sponsor, known as the group policyholder. 2.1.5.3 Members and scope of coverage to other insured persons. Under group policies, the person or member whose life is insured is known as the group life insured. Group plans define who is eligible for coverage, which typically includes the members, also called participants or enrollees of the group and their families. In the case of employer-sponsored plans, some basic coverage provided on the employee will be mandatory. Coverage may also include spouses and children, typically further defined by age or financial dependency, or educational status as full-time students. Many plans offer the ability to apply for optional, increased insurance coverage, which is subject to individual underwriting. One reason membership in an employee group plan is mandatory is so that the insurer can count on a relatively constant number of lives, upon which the premiums may be calculated. Another reason is to prevent the anti-selection of the risks. Enrolling in the plan usually must happen within a defined short time after gaining employee status. Subject to the provisions of the plan, making coverage changes is usually limited to an annual event, or perhaps to the times when there are life changes in the group life insured situation, such as marriage, births, or adoptions. This limits the changes in the coverage in force, which reduces the amount of premium recalculation that must be done to price the annual renewal. 2.1.5. For beneficiaries. Although not parties to the group master policy, under provincial insurance legislation, 110 the group life insured may designate beneficiaries to receive the insurance benefit for which they are the life insured. 2.2 Formation of policy. In common law, a contract is not formed until there is both an agreement as to what is being contracted for, i.e., a meeting of the minds about the insurance policy's subject matter, and an exchange of value, including a promise, to make the insurance policy binding. With life insurance, the insurer is simply promising to pay the defined insurance benefit if the insured pays the premium. 2.2.1 Rules about forming an individual insurance contract. The process of forming any contract is often described as having two steps, called offer and acceptance. The offer may be outstanding for a limited period of time, according to its terms. If not accepted, it may be withdrawn. With an insurance contract, the concept of offer and acceptance is unique. An insurance agent presenting a proposal to a potential client is not representative of an offer of insurance in the standard offer acceptance principles of contracting. Rather, in practice, the completion of an insurance application by an individual is generally considered an offer where the individual becomes the offeror. Then, in practice, the offer is generally accepted when the insurance carrier issues the contract and the contract is delivered to the applicant. However, under the law of the Canadian common law jurisdictions, it is the insurer's tender of the policy which constitutes the offer, and the acceptance takes place only when the applicant decides to receive the policy. Tender of delivery by the insurer is its offer and indicates its willingness to insure the risk, not a binding contract, which is consummated only when the insured accepts the policy on delivery. The insurer and the applicant have clearly effected the contract, and that is the point of view where it may be said that the contract is made. 111. In comparison with ordinary contracts, life insurance policies have several additional requirements before they are considered to be valid and in effect. The sections below explain the rules. Black small square application for insurance and representation of risk. Black small square temporary or conditional insurance coverage. Black small square changes in insurability. Black small square acceptance of application by insurer. Black small square payment of initial premium. Black small square delivery of policy. 2.2.1.1 Application for insurance and representation of risk. The application form completed by the applicant and proposed life insured, with the assistance of the agent, is an important part of forming the policy. It is the policyholder and the insurer who are the parties to the policy, but the role of the agent is very important, since it is his role to help the applicant understand and correctly answer the questions. It is crucial that the agent not paraphrase or change the wording of the questions created by the insurer, which can be lengthy, so that the response given is as complete and accurate as possible, leading to no doubt that the risk to be underwritten has been completely disclosed. This allows the insurer to adequately assess the risk it is about to underwrite. The answers recorded in the application are also the benchmark against which changes in insurability are later measured when the insurance policy is issued. Example: the question on the life application form specifically asked, "Have you ever been treated for or had any known indication of disease or disorder of the brain or nervous system, such as?" and then listed 21 separate symptoms, conditions, diseases, or problems. Georgina, the agent, wanting to save time, just asked the proposed life insured, "You don't have any problems with your nerves, or brain tumors or anything, do you?" The validity of the resulting policy will be open to challenge, and if anything goes wrong, Georgina will be involved in the lawsuit for failing to perform her duties. All of the answers provided by the applicant and the proposed life insured when the proposed life insured is different from the applicant, on both the application form and any additional documents such as a questionnaire constitute representations to the insurer that it will rely upon during the underwriting process. Policy applicants and the proposed life insured are asked to warrant the accuracy and completeness of their answers by signing the application and other documents after completion of the application. Ethics and Professional Practice Chapter 2 Insurance Policy Provisions 47 2.2.1.2 Temporary Insurance 112. An applicant may be able to obtain temporary coverage during the underwriting process if he can answer no to 3 or 4 temporary insurance questions confirming his good health and that he has not been in hospital or ill. This separate insurance agreement can provide limited insurance coverage, typically for 90 days. It will expire once the policy applied for is approved or declined, and is subject to terms and conditions outlined in a separate temporary coverage agreement. If the proposed insured person dies before underwriting is completed or the policy applied for is issued, the insurer may be obligated to pay a death benefit under the provisions of the temporary coverage. The amount of temporary insurance coverage available varies between insurers, but is typically set as the lesser of the face amount being applied for, or a maximum limit set by the insurer. 2.2.1.3 Changes in insurability. If there has been a change in insurability between application and policy delivery, the policy does not take effect, even if it was delivered, and the first premium taken. 113 This is because a change in insurability means the risk disclosed in the application and underwritten by the insurance company is different than the actual risk present at the time the policy is delivered to the policyholder. The insurer is entitled to know and consider any change in risk before being bound to the coverage. This is the case whether the policyholder and the life insured knew about the change in insurability or not. 114. How difficult it may be to prove that a change in insurability occurred between the application and time the policy is issued will vary from case to case. Both the policyholder and the proposed insured person have a duty to disclose to the insurer any change in insurability that is within their knowledge, from the time of making of the application until the policy is delivered. It may be hard for an applicant to know what a change in insurability might mean, since that is essentially an underwriting concept. This could relate to any aspect of insurability, such as a significant change in the life insured's health or the prescription medication he or she takes. George applied for life insurance in October. In November, he went to his physician to get a routine influenza shot. The insurance policy was to be delivered in early December. If George is asked by the agent about changes in his insurability, he could truthfully answer none, even if he is not entirely sure what that means. But if George is asked whether anything has happened that would change an answer in his application, he must answer yes, and disclose his medical appointment and influenza shot, since applications typically ask about the date of the last visit to the doctor and any treatment prescribed or recommended. The insurance company can then decide if the updated information changes anything. In this case, they would give the agent permission to go ahead and deliver the policy. 2.2.1. For approval of application by insurer. If the insurer decides to make an offer of insurance, they will notify the applicant of their underwriting decision and prepare a policy to be delivered if the applicant indicates they wish to go ahead. The policy tendered may include changes from the presumed terms and conditions the applicant contemplated when they applied. This may include a different underwriting classification, either better or worse than applied for. It could contain exclusions to the proposed coverage and changes to the premium to be paid by the applicant if the offer is accepted. 2.2.1.5 Delivery of policy. If the applicant indicates that they will accept the insurance policy offered, the policy will be printed out and sent to the agent for delivery to the applicant, together with any instructions relating to delivery requirements. If there are no delivery requirements and money has already been received, it may be sent directly to the applicant. 115. The policy is not in force until all delivery requirements have been obtained and the first premium paid. If a premium was submitted with the application, and the application is accepted, then the insurance comes into force on an effective date, the policy in force date, determined by the insurer. Sometimes the applicant requests, and the insurer agrees, to backdate the policy in order to conserve a younger age of the life to be insured for premium calculation purposes. In such situations, the applicant will also have to pay the premiums for the backdated coverage. If no premium has been submitted and the policy is being applied for as cash on delivery (COD), then the insurance will not be in force until payment is received by the insurer after the policy has been delivered. 2.3 Term and termination of policy. A policy may be annulled or cancelled either voluntarily by the owner or for limited specific reasons by the insurer, discussed in the section Termination by the insurer. It may also come to an end and expire. The differences between these are discussed below. 2.3.1 Rescission, 10-day free look. When an individual policy is delivered, the policyholder is said to have a 10-day free look. This is to allow him time to review the policy to confirm that it is consistent with what was expected when he applied for the policy. During this time, he can change his mind and return the policy for a full refund. The policy is effectively annulled. The technical term is rescission, meaning the contract is withdrawn or rescinded. The terms of the policy will govern the contractual right to rescind the contract. Guideline G10 of the Canadian Life and Health Insurance Association, CIWM, 116 calls for this 10-day free look in the case of individual life insurance contracts and individual accident and sickness insurance contracts. 117 Therefore, a policyholder can rescind an insurance contract within 10 days of signing it or accepting delivery of the policy, without penalty and with a reimbursement of the premiums paid. For individual annuity contracts relating to segregated funds, there is also a 2 business days rescission right under CIWM's Guideline G2 entitled Individual Variable Insurance Contracts Relating to Segregated Funds S for .1H.118. 2.3.2 Surrender. Individual life policies are referred to as unilateral contracts, in that the individual policyholder can always cancel the policy at any time. A policyholder can surrender a policy at any time, resulting in a complete termination of rights under the policy for both the policyholder and any beneficiary. If the policy has cash surrender values, CSV, those will be paid out subsequently to the policy termination, once they are calculated. Surrender does not necessarily result in a cash surrender value, because that will depend on the type of permanent insurance and policy funding levels, but even a renewable term policy may have unused/unearned premiums which insurers will return to the policyholder, in accordance with the terms of the policy. 2.3.3 Expiry or termination. A life insurance policy, or some coverage under it, may simply terminate in accordance with its terms. For example, a policy of term life insurance may have a finite duration of coverage for a number of years, or to a particular age at which point it expires. The coverage simply comes to an end as planned. Guaranteed renewable and convertible term policies have age limits. They cannot be renewed after a specified age, and they also cannot be converted to permanent insurance after a specified age. Guaranteed renewable term policies have an eventual termination date, at which point the policy and its coverage simply expire, in accordance with the terms of the policy. 2.4 Termination by the insurer. In some circumstances, life insurance policies can also be cancelled by the insurer before their coverage expires. Possible reasons are discussed in the following order: black small square termination for fraud, misrepresentation or concealment, black small square termination for non-payment of sickness or accident insurance premiums, black small square termination for non-payment of life insurance premiums. 2.4.1 Termination in the event of fraud, misrepresentation, or intentional concealment. An applicant for insurance and/or the proposed insured person, if they are not the same person, commit insurance fraud when they do one of the following: black small square make a deliberate misstatement, black small square deliberately omit to inform the insurer of a material fact, black small square obtain insurance for which the policyholder or insured person does not qualify. Examples: black small square failing to disclose that the proposed insured person was recently treated for cancer, black small square claiming to be a non-smoker when the person in fact smokes, black small square claiming to need the insurance for personal reasons when in fact the policyholder intends to sell it to someone else. Unlike misrepresentation and concealment, fraud includes an intent to mislead the insurer. When fraud is involved, the incontestability period does not apply. 119. If an applicant or the life insured made a misrepresentation or concealed some material fact in the course of the application, several outcomes are possible depending on whether the misrepresentation was innocent or fraudulent, and when it was discovered. This can arise during one of the following periods: black small square during the application process, black small square within the first 2 years, black small square after 2 years. 2.4.1.1 During the application process. If the applicant misrepresents some factual information, the insurer would be entitled to adjust the proposed coverage to that which the premium would have acquired if the truth had been known. Since no policy has been issued yet, it is really a question of whether the insurer wishes to continue gathering evidence of insurability, or whether they have lost confidence in the truthfulness or motivation of the applicant and wish to decline the application. Example: Josephine did not want to write her true age on the application form, and said she was 5 years younger than she really is. When her agent verified the application form with her identification, he saw the misrepresentation of age, corrected the application, and adjusted the coverage sought accordingly. If a mistaken age was somehow not discovered until the policy was already in force, including because the applicant lied, the different insurance acts contain statutory protection against termination for misstatement of age. 120 The insurer would be entitled to amend the contract and adjust the coverage to match premiums paid, unless contractual age limits for policy coverage issued would be violated, in which case termination could be effected, or adjust the premiums to the correct amount for the true age. 2.4.1.2 Within the first 2 years. If a misrepresentation or concealment other than age that is in good faith is discovered during the first 2 years of the policy, the insurer would have the option of canceling the policy. It would have to determine whether the discrepancy was significant enough to take action. This 2-year period is known as the statutory incontestability period. 121 If the insurer does not cancel the policy, it would remain in effect. After the expiry of the 2-year period, the insurer can no longer cancel the policy for misrepresentation or concealment that was in good faith. Example: Jacob takes out a new life insurance policy in September. In answering the questions about tobacco usage, Jacob denies ever using any form of tobacco. He forgot that he smoked a cigar at the charitable golf tournament he participated in last month. A picture in the local paper shows him with a cigar in hand, celebrating with his winning foursome. His agent sees the picture, contacts Jacob and explains the risks he may be running by not clarifying his mistaken answer with the insurer. Jacob elects to complete a tobacco usage questionnaire, confirming his single usage of a cigar, and has his agent bring his mistake to the attention of the insurance company. The insurer decides to take no action. The 2-year incontestability period ends and Jacob is now protected against the insurance company changing its mind about his inadvertent misrepresentation. 2.4.1.3 After 2 years. Once the policy has been in force for 2 years, the insurer can only cancel it based on a fraudulent misrepresentation or concealment. Insurance fraud is an attempt to get insurance that would otherwise not be offered, or to acquire it on better terms than the applicant was entitled to on a true statement of the facts. It is sometimes described as intentional deception or reckless disregard of the truth. The person answering insurance application questions either intentionally answers incorrectly or does so without caring if the answers are incomplete or untrue. An insurer may cancel an insurance policy at any time for fraud, including a claim for a death benefit. The incontestability period will not protect the policy. 122. Example: Arn dies of bowel cancer 3 years after buying a policy. A thorough review of his medical history in response to the claim for the death benefit reveals that Arn had a previous round of bowel surgery for cancer 4 months before he applied for the insurance. But he stated on the application that he had never had any indication of or treatment for cancer. Arn committed fraud, deliberate misrepresentation, and concealment. The insurance company refuses to pay the death claim. 2.4.2 Termination for non-payment of sickness or accident insurance. Premiums. For insurance to remain in effect, the policyholder must pay premiums when they are due according to the insurance contract. If a policy has been issued or a renewal certificate has been delivered, even in error, and the premiums have not been paid, the policy will stay in force until a termination notice is sent. 123 The insurer may terminate the policy for non-payment by mailing a postage prepaid, registered, written notice of termination to the last known address of the policyholder. The notice of termination will take effect, and the coverage will end after 10 days, written notice measured from the day after it is mailed. 2.4.3 Termination for non-payment of life insurance premiums. If life insurance policy premiums are not paid in a timely fashion, any term life policy or permanent life policy with no cash values will also terminate, subject to a 30 days grace period. 124. Agents should be aware of the specific termination features of a policy. A number of exceptions may exist to the termination for non-payment of premiums, especially when the policy has a cash surrender value. The agent should always be aware of the termination features to properly guide his clients. The cancellation is not final, however, since the insurer is obliged to reinstate the individual life insurance under the following conditions. Black small square the client applies for the reinstatement within 2 years of the date of the cancellation, and black small square the insurer determines that the insured still meets the insurability conditions of the cancelled contract. 125. 2.5 Assignment of a policy. 2.5.1 Absolute assignment. Absolute assignment of a policy by the policyholder is the transfer of ownership of the policy. Agents should investigate the possible consequences of an assignment before advising clients. About insurance policy transfers. A change in ownership is a disposition for tax purposes and may result in taxable gains for the assignor, the person who becomes the new owner. The absolute assignee has all the rights of the original policyholder, the assignee, including the right to designate a new beneficiary or to withdraw money from the policy. The right to assign a policy is not unlimited in all provinces and territories. In some provinces, certain forms of trading, buying and selling life insurance policies are considered trafficking and are prohibited. 126. These are variously called viatical settlements, or life settlements, or stranger-owned life insurance, STOLI. Individuals may be induced to sell their existing policies during life as a means of raising necessary funds. 127 Alternatively, they may be induced to apply for new life insurance, and then assign ownership of the policy to a third party in exchange for payment. 2.5.2 Collateral assignment. Some kinds of permanent policies may have substantial cash surrender values, in addition to a death benefit. This means they may be acceptable to third-party lenders as additional collateral for a loan. This is called collateral assignment, in contrast to absolute assignment discussed earlier. This means the policyholder assigns ownership of the policy to the lender, but only as collateral. This restricts the policyholder from doing anything with their policy that could affect the value of the security. When the loan is paid, the collateral assignee releases their right to the policy, and full ownership reverts to the original policyholder. If the life insured dies, the lender/collateral assignee is only entitled to enough of the policy death benefit to retire the loan balance. 128 The remainder, if any, belongs to the insurance beneficiary. 2.6 Product-specific policy provisions. This part of the chapter will review the specific policy provisions of the following products. Black small square individual life insurance. Black small square group life and health insurance. Black small square individual and group accident and sickness insurance. Black small square annuities. Black small square segregated funds, individual variable insurance policies. Black small square pension products and other group annuity products. 2.6.1 Individual life insurance. Individual life insurance policies come in many different forms. However, all contain basic provisions, required by Provincial Insurance Law, 129, which are necessary to define and document what the policy covers and what it will cost. Since the insurer is required to issue an insurance policy to the policyholder, 130 the latter will be aware of the terms and conditions contained in the policy. These provisions are typically summarized on a page containing the policy particulars. 131 This includes black small square the name or a sufficient description of the insured and of the person whose life is insured. Black small square the amount or the method of determining the amount of the insurance proceeds payable by the insurer and the conditions under which the amount becomes payable. Black small square the amount or the method of determining the amount of the premium and the period of grace, if any, within which it may be paid. Black small square whether the contract provides for participation in a distribution of surplus or profits that may be declared by the insurer. Black small square the conditions upon which the contract may be reinstated if it lapses. Black small square the options, if any. White small square of surrendering the contract for cash. White small square of obtaining a loan or an advance payment of the insurance money, and white small square of obtaining paid-up or extended insurance. If the policy grants contractual rights so that it can be renewed or converted, the terms and conditions governing those rights must be explained. These terms must include whether the cost of the coverage on renewal is fixed in advance or not, and how it would be determined on renewal or conversion. 2.6.1.1 Statutory conditions. The Provincial and Territorial Insurance Acts exert considerable control over provisions that are incorporated into life policies. This includes a requirement that all the policy terms and conditions must be set out in full when the policy is issued. 132 The following documents constitute the entire agreement between the parties. 133. Black small square application. Black small square policy. Black small square any document attached to the insurance policy when issued. Black small square any amendment, also called rider, endorsement, or addendum, to the policy agreed to in writing after the policy is issued. 2.6.1.2 Reduction. Some policies contain customized provisions that affect the coverage offered, or the amounts payable under a particular coverage. Some policies have a death benefit that reduces in amount as the life insured attains stated ages. A contractual reduction in face amount does not affect the insurer liability for payment upon death, only the amount to be paid. Example: Regina purchased a reducing term policy which ran to age 70. The policy death benefit contractually reduced to $25,000 at age 60, further reduced to $10,000 at age 65, and will terminate coverage at age 70. 2.6.1.3 Exclusion. In contrast to a reduction, an exclusion is a change to the coverage provided. Death caused by some exclusion in the insurance policy would not result in any policy benefits. Nikki purchased a large individual life policy, but due to her having a pilot's license and her frequent involvement with both flying in private planes and practicing underwater sports, the policy contained two exclusions: 1. Death caused by or as a consequence of underwater diving, and 2. Death caused by flying in a plane as other than a fare-paying passenger, i.e., as a pilot or crew member. 2.6.1. For exclusions, contractual or imposed by law. Contractual exclusions are specified in the policy. Exclusions imposed by law are established by decisions made by the courts. They may relate to actions that are deemed a violation of public order, or because the beneficiary or insured caused or ran the very risk insured against, which constitutes grounds for denying entitlement to insurance proceeds. Example: Ron owned and was the beneficiary of a life policy on his wife, Melissa. He was convicted of her murder. In common law, it is against public order to permit wrongdoers to profit from their crime. Ron would be disqualified from being entitled to the death benefit. Melissa's children, on the other hand, would benefit from any insurance owned by her and payable to them because they were innocent parties. 2.6.1.5 Pre-existing condition exclusions. Some policies also contain exclusions for death caused by or related to pre-existing conditions. This exclusion is more common under disability insurance, where diagnosed medical conditions that are not usually life-threatening can ultimately cause a person's disability. Disability benefits might be excluded and unavailable to compensate a related disability suffered by someone with a pre-existing hearing loss or a history of back problems, even if the conditions had never caused time off work before they applied for the insurance. 2.6.1.6 Suicide Clause. Committing or attempting to commit suicide is not illegal, but a policy does not have to provide a benefit if a person insured commits suicide. Most individual policies will pay, but restrict paying the death benefit, if death is caused by suicide or attempting suicide within the first 2 years that the policy is in effect or within 2 years of any reinstatement. After a policy has been in effect for a stipulated period of time, typically 2 years, the exclusion provision ends and the death benefit is payable, even if death is due to suicide. Provincial and territorial insurance statutes confirm that this is not a violation of Public Order. 134. 2.6.1.7 Living benefits. Some insurance policies entitle the policyholder to receive an advance payment of a portion of the death benefit if the person whose life is insured is diagnosed with a terminal illness and has only a short time to live. The time period can vary, usually death is expected in less than 2 years. Some other policies may allow the policyholder to withdraw cash values, if any are available, on a tax-free basis if the life insured is totally disabled. 2.6.1.8 Cash Surrender Value, CSV. Some kinds of permanent insurance provide for the buildup of cash values on either a contractually guaranteed basis or on a non-guaranteed variable basis dependent upon the performance of insurance policy investment accounts. If the policy is cancelled by the policyholder, the amount that they will receive in cash is called the Cash Surrender Value, CSV. It will be reduced by things such as outstanding policy loans, unpaid premiums, or insurance policy surrender charges. 2.6.1.9 Distinction between collateral loans and insurance policy loans. When a third-party lender takes a collateral assignment of a policy as security, there is no limit on the size of the loan apart from those established by the lender's loan underwriting criteria. If granted, the size of the loan will usually be a percentage of the value of the CSV. The percentage may be larger if the policy is invested in fixed income investments rather than equity-based funds. In contrast, an insurance policy loan has limits created by the taxation of life policy transactions. If too much money is borrowed on an insurance policy, it can trigger policy gains taxable as income to the policyholder. Agents need to be aware of this and inquire about the available loan amount and any taxable disposition before processing the policy loan paperwork on behalf of the policyholder. The insurer can readily provide this information. 2.6.1.10 Riders, Policy Amendments. With the agreement of the insurer, an insurance policy may have additional coverages added to it through documents sometimes called riders, more commonly now referred to as additional or attached benefits. These amendments may change existing benefits or provide additional coverages, example, term life insurance coverages on the life insured or a new life insured such as their children. 2.6.2 Group Life and Health Insurance. Group insurance means a type of insurance in which a single insurance policy, sometimes called a master policy, covers specified people who can be called plan members or participants, and their eligible dependents, against a specific risk or risks. The plan sponsor, called the group policyholder, or in legislation called the group insured, is the entity that contracts with the insurer. As such, as a matter of contract law, they are the party that determines which benefits will be the subject matter of the policy. The group policyholder may have obligations to other individuals perhaps created by collective bargaining, example, to arrange benefits, but these obligations have no effect on the group master policy. 2.6.2.1 Determination of the plan member group. The group must be clearly defined so that entitlement to coverage can be readily determined. Employees are easily determined by an employer. Membership in a union or professional association, such as chartered accountants in a particular province, is another easily determinable group. 2.6.2.2 Premiums and cost sharing. When the group policyholder is an employer, the employer is responsible for paying the premiums owed to the insurer, even though the cost sharing might be 50% by the employer and 50% by the employee. Non-payment of the premiums due under the master contract, perhaps by an employer in financial difficulty, can result in termination of the master contract. When the group policyholder is a professional corporation or professional association, the premiums are usually paid to the insurer directly by the members. The premiums charged for group benefits are not guaranteed. The costs of coverages are reassessed based on group census data, which are compiled, tracked, and provided by the group policyholder, and are averaged over the membership. The premiums can be changed annually by the insurer, and are an annual subject of negotiation, subject to the insurer's arrangement with the group policyholder. The premium calculation takes into account the insurer's claims experience, i.e., the ratio between the premiums collected and the benefits paid. Ethics and Professional Practice Chapter 2, Insurance Policy Provision 61. Example: Quality Corporation had a terrible year. 5 young employees were injured or became disabled through sickness, and went on long-term disability, LTD, benefits. Upon renewal, the group benefits insurer determined that the premium for the LTD benefit coverage had to rise very substantially. The agent provides renewal terms to Quality Corporation, and is asked questions on the changes to the premiums. The agent who has discussed renewal terms with the insurer informs his client that the insurer must set aside rather large reserves to fund a potential long-term disability, especially if a claimant is young and in the early stage of their working life. Those costs must be passed along to the group plan. 2.6.2.3 Types of group insurance. Group plans can cover a wide array of benefits including Black Small Square Life Insurance, Black Small Square Accidental Death and Dismemberment Insurance, Black Small Square Short-Term Disability and Long-Term Disability Plans, Income Replacement, Black Small Square Critical Illness Coverage, Black Small Square Health Care and Dental Care. 135. Whatever the private obligations that the plan sponsor may choose to assume towards its members, the relationship with the insurer, and the financial obligations of the insurer are governed by the terms of the master group policy. Coverage under these kinds of plans usually has defined annual dollar limits. The plan sponsor can adjust the coverage to suit their budget and the age and preferences of their employee population. Many employers offer the employee a dollar budget to allocate to their own choice of coverage, called flexible benefits. The coverage required can sometimes be stipulated in a collective agreement between the employer and the union that represents the employees. 136. 2.6.2. For administrative services only, ASO. Some large employers prefer to fund the benefits for their employees themselves, rather than paying premiums to an insurer to transfer the risk and costs, self-insurance. However, the plan sponsor may choose to hire an insurer to process, adjudicate, and administer claims and payments on their behalf. In that case, the insurer does not fund benefit payments. They are merely the conduit of funds provided by the employer. These plans are known as Administrative Services Only (ASO) plans. Because employers with ASO plans are self-insuring, these are not insurance plans, and they are not covered by provincial or territorial insurance statutes. Since July 1, 2014, long-term disability plans for federally regulated employees must be insured. 137. 2.6.2.5 Certificates. When members join an insured group plan, they do not have any contractual connection with the insurer. Their entitlement to the master contract is limited in most provinces and territories. Instead, the insurer gives the employer sponsor certificates in paper or electronic form to deliver to the group members. Certificates contain individualized information for the group, based on information relayed to the insurer by the group policyholder. It is up to the employer or group sponsor to distribute the certificates. Provincial insurance statutes typically prescribe the information that must be provided. For instance, the Ontario Insurance Act provides the following: 138. 177. In the case of a contract of group insurance, an insurer shall issue, for delivery by the insured to each group life insured, a certificate or other document in which are set forth the following particulars. 1. The name of the insurer and an identification of the contract. 2. The amount, or the method of determining the amount, of insurance on the group life insured, and on any person whose life is insured under the contract as a person dependent upon, or related to, him or her. 3. The circumstances in which the insurance terminates and the rights, if any, upon such termination, of the group life insured or of any person whose life is insured under the contract as a person dependent upon, or related to, him or her. 2.6.2.6 Booklets. Plan sponsors may also use booklets to explain the different group benefit coverages. These booklets are only summaries, not insurance policies. The provisions of the group policy with the plan sponsor govern in the case of any dispute. However, they usually contain enough detail that any covered member can determine the coverage they enjoy and the details thereof. The method of determining the basic amount of life insurance is often quite straightforward. Example, 2 times base salary. Under Section 6 of the CLHIA Guideline G3, when a group insured person leaves the group, he has, if under 65, a group conversion privilege to convert his group life insurance policy into an individual insurance policy, without having to undergo any underwriting. 139 This right must be exercised within 31 days after the date of termination of the plan member's life coverage under the group insurance contract. 140. 2.6.2.7 Access to copy of policy. Because different classes of employees are typically entitled to different benefit packages, the employer may not want those details provided to all members of the group. There is not the same legislative entitlement to a copy of the master or group policy as there is for individual insurance policies. Some provinces are moving towards increased availability of the master policy, even allowing plan members to obtain a copy of the master contract provisions. British Columbia, Alberta, Manitoba, and Ontario. 141. 2.6.2.8 Laws applicable to members' residence. Employees and group members may live in any province, and provincial law governs property rights, including insurance. The various insurance acts stipulate that the law of the province where a group life insured is residing, when he becomes insured. 142 is the law that applies in determining the insurer's rights and obligations, and the rights and status of beneficiaries under the group coverage. 2.6.2.9 Term and termination. Almost all group insurance policies are renewable annually. Group plan members must qualify for coverage when the group coverage becomes available to them. Coverage for group plan members ends when the group plan terminates, other than for members who deceased earlier or are already receiving long-term disability benefits when the group plan terminates. Group policy premiums are not guaranteed, and subject to negotiations with the group policyholder, the insurer may increase the price annually at the time of the contract renewal. The employer or group sponsor may decide to change the benefit mix, reduce benefits, or even terminate the master contract and change insurers. There are complex legislative provisions allowing the policy of one insurer to be transferred to another. 143. While the group master policy will continue, individual coverage generally terminates when an individual is no longer a member of the covered group, i.e., terminates employment, or becomes ineligible by becoming a member of some other group eligible for coverage under the group plan, such as a change of job with the employer. Group benefits often seem relatively inexpensive compared to individually owned coverage, but care needs to be taken in making the comparison. Optional group benefits may be available subject to much simpler underwriting than individual policies. But this may also mean rejection of an optional application in some cases, where an individual contract might be approved but fine-tuned through a rating or coverage exclusion. Depending on the group age and health and the group sponsor's contribution, group plan members may pay less than individual policyholders for similar protection, but they do not enjoy access to the portability and contractual guarantees available with individual policies. 2.6.3 Individual and Group Accident and Sickness Insurance. Accident and sickness insurance may be available in an individual personal contract, or as part of a group benefit plan, as seen in the section Types of Group Insurance. Individual or group accident and sickness insurance 144 can be acquired to protect against the following risks. Black small square accidental death and dismemberment, AD&D. Black small square disability specifics. Black small square drug insurance, black small square critical illness, black small square long-term care, LTC. 2.6.3.1 Accidental death and dismemberment, AD&D. This insurance covers the risk of the insured person suffering a defined physical loss or death due to an accident. The physical losses can include loss of limbs, or hearing or eyesight. The insurance policy indicates the amount of the death benefit, and the amounts payable for various levels of dismemberment or paralysis are often expressed as a percentage of that amount. The definition of what constitutes an accident in the insurance policy can be very complex. There may be many restrictions and exclusions to coverage, situations in which an insurer will not pay a benefit. Subject to the terms of the insurance policy, these exclusions could include black small square death from or involving sickness, black small square illness, black small square bodily or mental infirmity or disease, black small square suicide or self-inflicted injury, black small square war declared or undeclared, black small square riot, black small square events involving the ingestion of alcohol, drugs, poison or sedatives. Black small square events involving the commission of a criminal offense or assault. Black small square extreme sports, racing, black small square certain surgical mishaps. As a result of this, processing a death claim may take some time, since determining that death was accidental and not affected by some exclusion may not be a simple process. 145 Accidental death insurance can be very helpful in providing at least partial protection to persons who are medically unable to qualify for traditional individual life insurance. Personal accident insurance can provide hospitalization benefits and funds to cover some loss of income and out-of-pocket expenses after an accident. 2.6.3.2 Disability specifics. Individual disability insurance coverage can be very complex, as it can cover both full and partial disability, as well as temporary or permanent reductions in the ability to earn income. The insurance policy can give the policyholder the ability to purchase additional income protection at certain points in time, without going through medical underwriting again. This optional increase permits the policyholder to increase coverage to keep pace with increases in income. It is typically called a future income option, FIO. Disability coverage does not come into effect until the insurance policy is delivered to an applicant who has confirmed that they continue to be in good health and the premium is collected. The policy will contain a policy in force date. This is the date when coverage begins. 2.6.3.3 Drug insurance. Clients may choose to purchase their own health insurance covering the cost of expensive medication. They would be both the policyholder and the life insured. This type of personal coverage is similar to group benefits coverage and is usually part of a personal health insurance plan that covers drugs, dental and out-of-country or extended expenses. These individually owned, private plans can vary widely in terms of the drugs they cover, the extent of coverage, deductible amounts before coverage commences, co-payments or cost sharing on prescriptions, and caps on benefits. Some are based on covering any prescription if issued on an outpatient basis. Other insurers may cover drugs on a defined list or formulary. 2.6.3. For critical illness, CI. Critical illness, CI, insurance started out as cancer insurance and rapidly expanded to cover heart attacks, strokes, and other illnesses. It insures against the risk of a person suffering a life-threatening illness. If the person is diagnosed with a covered critical illness and survives for a period of usually 30 days, the insurer pays a lump sum amount. Coverage can now be obtained for a wide array of critical illnesses. Some insurance policies include up to 25 covered critical illnesses, and insurers may offer additional benefits. Today, those features could include a return of premium, ROP, on death, or cancellation of the policy benefit. If the policy has been in force for a set number of years and is cancelled, or the life insured dies without making a claim, the policyholder can designate a beneficiary to receive the benefit. This opens the possibility of there being the same parties to a critical illness policy as to a life policy, namely the insurer, the policyholder, the life insured, and beneficiaries of the return of premium benefits, which could be different. The insurance policy and benefits may also be held jointly. It is worth noting that critical illness insurance as a product is not yet addressed by the provisions of the Income Tax Act, and the inclusion of a ROP benefit on death, in particular, may confuse the classification of the policy as accident and sickness insurance. The law is evolving in this area. 2.6.3.5 Long-term care, LTC. Long-term care, LTC, insurance provides a benefit when the insured person cannot safely and independently perform a number of daily living activities, or must be constantly supervised due to deterioration of mental functions. Some insurers offer a weekly or monthly benefit amount that is like an income benefit. It is not an actual income benefit because it does not replace income. The benefit can sometimes be used any way the policyholder chooses. Other insurers only reimburse expenses based on daily living activities, which include things like black small square feeding oneself, black small square getting dressed, black small square grooming and hygiene, including bathing, black small square getting in and out of bed, black small square using the toilet. Disability and long-term care insurance may cover services in a variety of settings, at home, through adult day care, in a retirement home, assisted living setting, or a long-term care facility. Services may include black small square nursing care, black small square rehabilitation and therapy, black small square personal care, help with daily living activities such as dressing, eating and bathing, black small square homemaking services, cleaning, laundry, preparing meals, black small square having another person there to watch over the insured and to help them when, where and as needed. All disability and long-term care insurance plans in Canada have a specific wait period before benefits are payable, usually 30 days, 90 days, 180 days or longer. 2.6.3.6 Parties. As with other kinds of insurance, the policyholder enters into a contract with the insurer, but the policyholder and the person insured for accident and sickness insurance do not need to be the same person. In some cases, a corporation or partnership may own accidental death, disability, or critical illness coverage on a key employee, partner, or shareholder. If that individual dies or becomes disabled or suffers a covered condition and survives, as the case may be, benefits will be paid to the corporation or partnership and may be used at their discretion, subject to any private agreement relating to the use of the proceeds. Note that there may be co-owners of an insurance policy. 2.6.3.7 Rights of parties. The rights of the policyholder and the beneficiary are governed by the insurance policy. The provincial and territorial insurance statutes also contain provisions relating expressly to accident and sickness insurance. 146. 2.6.3.8 Effective date. Because no medical underwriting is necessary for personal accident or accidental death or dismemberment insurance, the policy can take effect quite quickly, sometimes immediately on the insurer's acceptance of the application. In contrast, sickness insurance, which requires underwriting and collecting evidence of insurability, will require a similar process and timeline to applying for individual life insurance. The policy will specify an effective date of coverage. 2.6.3.9 Termination of accident and sickness insurance. The insurance policy can be terminated by the policyholder at any time on giving written notice and surrendering the policy. If the policyholder stops paying the premium, the policy will be terminated for non-payment of premiums after the expiry of the grace period defined in the policy. However, unlike life insurance, a 10 days written notice of termination is also required if it is being mailed to the client, measured from the day after it is mailed. 147. More importantly, unless their provisions have been adjusted to make the policy non-cancelable, 148 accident and sickness policies may only be terminated by the insurer after it sends written notice and once the period indicated in the insurance policy expires. Non-payment of the premiums in and of itself therefore does not allow the insurer to terminate such an insurance policy. The formalities mentioned above must be followed for the policy to be cancelled. For this reason, policies that include this kind of provision are referred to as cancelable. However, insurers may modify their contracts to delete the right to cancellation on notice, since that change is in favor of the life insured. 2.6.3.10 Statutory conditions. Also, unlike life insurance, there are statutory terms and conditions 149 that must be included in every individual accident and sickness policy for the policy to be valid. The insurer must also issue an insurance policy when an individual takes out coverage, and the policy must contain black small square the name or a sufficient description of the insured and of the person insured. Black small square the amount or the method of determining the amount of the insurance money payable and the conditions under which it becomes payable. Black small square the amount or the method of determining the amount of the premium and the period of grace, if any, within which it may be paid. Black small square the conditions upon which the contract may be reinstated if it lapses. Black small square the term of the insurance or the method of determining the day upon which the insurance commences and terminates. Group accident and sickness policies have similar requirements, and like other group plan benefits, a certificate must be issued confirming basic coverage details. 150. 2.6.4 Annuities. Annuities are policies issued by insurers or other financial institutions where they agree to pay a fixed amount to a payee over a specified period of time. Annuity contracts may be used as investments, financial security, tax planning, estate planning, and/or creditor protection. If the duration of the payments is determined by a person's life, it is called a life annuity. If the payments are for a defined period of time, it is called a term certain or fixed-term annuity. Only companies authorized to conduct life insurance business can offer life annuities. Annuities, life annuities as well as fixed-term annuities, issued by life insurance companies are treated as life insurance under the various provincial and territorial insurance acts. 151. Annuities can be issued as individual or as group annuity contracts. Annuities can be purchased as registered contracts, RRSP, RRIF, TFSA, RRP, DPSP, LIF, LIRA, etc., or as unregistered contracts. Annuities can be deferred or immediate. The following annuity contracts are available on the market. Black small square annuity contracts relating to segregated funds, which may be available as an individual, called Individual Variable Insurance Contract, IVIC, or group annuity. This type of annuity is a deferred annuity. Black small square guaranteed interest accounts, GIA, which may be available as an individual or group annuity. This type of annuity is a deferred annuity. The amounts, called contributions or premiums, are alienated by the holder to the insurer to purchase a non-variable annuity contract, for example, a guaranteed interest account, GIA, with 3% interest for 5 years, are paid into the insurer's general funds. This type of annuity contract resembles a guaranteed investment certificate, GIC, issued by banks or credit unions. Black small square immediate annuity contracts, which may be available as an individual or as part of a group annuity contract. 2.6. For 1 parties. The following parties are involved in an annuity policy issued by an insurer. Black small square the insurer, the debtor, or annuity provider, which is the entity that provides the undertaking to pay the periodic amounts. Black small square the policyholder or annuity holder, as with other forms of life insurance, is the individual or corporation that contracts with the annuity provider. The annuitant or life insured is the measuring life on which the duration of a life annuity is based. Black small square the policyholder may designate a named recipient, called the annuitant grantee, to receive the actual annuity payments. If the annuity contract is registered, the policyholder, the annuitant and the annuity grantee will be the same person. Black small square the designated beneficiary. Annuities, other than those derived from registered plans, may be owned by individuals, corporations or trusts. An owner who is not the measuring life may designate a successor owner, as with other life insurance policies. 152. 2.6. For 2 the policyholder. As with other insurance products, it is the policyholder who has the right to determine to whom the payments will be paid. If there is a guaranteed number of payments that will be paid, regardless of how long the measuring life lives, the policyholder may designate a beneficiary for the remaining payments in the guarantee period after the death of the measuring life. The policyholder is often referred to as the annuitant in annuity contracts, or as the investor. Under the Income Tax Act, Canada, the annuitant is the owner of the registered contract, RRSP, RRIF, etc. It is important to carefully read the definitions of the annuity contract, since the wording of the different parties of the annuity contract might be different from one annuity contract to another, or from one insurer to another. 2.6. For 3 annuitant, life insured. When talking about annuities, people often refer to the annuitant as the person who will be receiving the annuity payments. But this person is simply the measuring life on which an annuity is based. They do not always get the payments. The annuitant must be a natural person who has a lifetime. Often, there is more than one life. On the death of the first annuitant, there may be a second or successor annuitant, most often a spouse. Life insurance companies can offer a deferred annuity, which will exist for a period of time before payments commence, if there continues to be a life contingency, and therefore a measuring life annuitant. 2.6. For payee. This is the person to whom the annuity payments will be directed by the policyholder. It could be the policyholder himself or some other payee, including a corporation or trustee. Once payments have begun under a life annuity, it cannot be commuted to a lump sum. The payee is sometimes called the annuity grantee, but is also often referred to as the annuitant. Again, it is important to look at the definitions of the annuity contract in order to avoid confusion. For all registered contracts, RRSP, RRIF, LIF, LIRA, DPDP, TFSA, etc., the policyholder, the annuitant, life insured, and the payee are always the same person. For non-registered annuity contracts, even if, most of the time, the policyholder, the annuitant, life insured, and the payee are the same person, it is possible to have 2 or 3 different persons with respect to the policyholder, the annuitant and the payee, for instance, X acting as the policyholder and annuitant, and Y as payee, or X acting as policyholder, Y as annuitant etc. as payee. Ethics and professional practice. 2.6.4.5 Immediate annuities. Annuities called immediate or payout annuities provide that the first payment will begin on the next defined periodic annuity frequency period, whether that is monthly, quarterly, semi-annually, or on the first anniversary date, annually. Deferred accumulation annuities. As the name suggests, these plans permit the investment and accumulation of income over time, with payments to start later. The start date of the periodic payments is called the maturity date. These policies are also called deferred annuities. During the accumulation phase, they are subject to annual accrual taxation under the Income Tax Act, based on the annual policy date. Registered accumulation annuities, which are a form of registered savings plan where all the income will be taxable upon payment, are not subject to accrual taxation. Withdrawal and surrender rights. With respect to immediate annuities, as with most long-term, interest-bearing vehicles, withdrawal or surrender while the annuitant is alive is not anticipated and not generally permitted. Death may trigger liquidity, subject to the terms of the insurance policy, annuity contract, including possible market value adjustments, MVA. Because it qualifies as insurance, death of a sole annuitant will trigger payment of the balance of the annuity to the named beneficiary, failing which to the estate of the policyholder. With respect to deferred annuities, withdrawal or transfer while alive are generally permitted in the case of annuities related to segregated funds, subject to the terms of the insurance policy, including a possible market value adjustment, MVA, and withdrawal fees. Since it qualifies as insurance, the death of a sole annuitant before maturity will trigger payment of the balance of the policy to the named beneficiary or, if none, to the estate of the policyholder. However, with respect to GIAs, as with most guaranteed rate, interest-bearing vehicles, withdrawal and transfer while the annuitant is alive is not anticipated and not generally permitted. Death may trigger liquidity, subject to the terms of the policy. 2.6.4.6 Group annuities. Group annuity contracts may be entered into by a group, such as an employer, a union, a professional corporation or association, for the benefit of their employees or members. An employer may use a group annuity contract with a life insurance company to capitalize a pension fund, a PRPP, pooled registered pension plan, a group RRSPs, a DPSPs, as well as other registered or unregistered contracts. The plan administrator holds an annuity policy for the benefit of all the members of the plan, who make contributions to it or for whom contributions are made. As an annuity falls within the definition of insurance, there are fewer rules for managing it than for individual annuities, which could lead to lower administration expenses. The parties to a group annuity contract are typically the group plan sponsor, which could be an employer, a union, a professional corporation or professional association, and an insurance company willing to provide for annuities to the group plan members through a group annuity contract. The plan members are typically the members of a specified group, i.e. employees, association members, etc. 2.6.4.7 Structured settlements. Structured settlements 153 are a special kind of single premium annuity, non-assignable, non-commutable, and non-transferable that is accorded special tax treatment. Instead of a court awarding, or the parties to litigation agreeing on, a lump sum in damages, a structured settlement means that the court awards or the litigants agree to a customized stream of damage payments to be funded through the purchase usually by the defendant or the defendant's insurer of a structured settlement annuity. From a tax perspective, damages paid for personal injury caused by a wrongdoer are considered to be compensation for loss of the ability to earn an income, not on account of lost income itself. 154 This means the money is on capital account, and simply puts the injured party back where they were before they were injured, so no tax is payable on the receipt. Lump Some, single, payments to settle court proceedings have some advantages such as finality, but also some downsides, including the need for money management and the risk of dissipation of the money, leaving the injured party with greater than average needs and financial difficulties, but without further recourse. The stream of payments from the annuity policy does not result in any taxable income to the recipient, provided they are designed in accordance with principles outlined in the Canada Revenue Agency's CRA Interpretation Bulletin IT 365 or 2, dated May 8, 1987. This includes not being purchased by the injured party or someone on their behalf. Payments from the annuity are irrevocably made to the injured party, and the at-fault party or their insurer must remain liable for the payments set out in the annuity policy. It could also be a life annuity from an insurer to fund payments in accordance with the settlement agreement the parties reached to put an end to the litigation. 2.6.5 Segregated Funds. An individual variable insurance contract, IVIC, is in fact an individual annuity contract related to segregated funds. It means that premiums paid are invested in segregated funds managed by the life insurance company. The value of the policy will vary over time based on the value of the investments. The investments are owned by the insurance company, which credits values to the policy if the underlying funds grow in value. The values can go down if the market goes down, and the money being paid out of the policy can vary, which is why they are called variable. These policies guarantee to pay at least 75% of what the policyholder paid to the plan before age 75, on death or maturity, even if the investments are worth less. 155. The parties to the policy are the same as for an annuity. Policies are established when the application for the policy is accepted by the insurer, and the first payment is received along with any other opening requirements needed by the insurer. The details of an IVIC can be complex. They are governed by insurance legislation, not securities law. Instead of a prospectus, disclosure regulations require that insurers provide a stipulated collection of information about the policy at the point of sale, in a language that is reader-friendly, before a policy for an IVIC is accepted. 156. This is called an information folder. Specimens of the information folder must also be filed with some provincial insurance regulator before any applications may be accepted, and be kept up to date. 157. Other documents must also be remitted by the life insurance agent at the point of sale, to the client, such as the fund facts and the key facts. 158. They are often inside the information folder. A copy of the application form must also be remitted to the client. The Canadian Life and Health Insurance Association, CIWM, is an association of 99% of all insurers conducting business in Canada. It has prepared a series of 18 guidelines, on a wide variety of topics, for the guidance of its members to promote consistent practices and standards for the life and health industry. Guideline G2159 discusses IVICs relating to segregated funds. Guideline G2, which sets out the requirements for an information folder, is a regulatory requirement in Ontario. 160. The CIWM website provides the following information on the Guideline G2. The CIWM Guideline G2, Individual Variable Insurance Policies Relating to Segregated Funds, establishes industry standards including standards for Black Small Square Advertising Disclosure, Black Small Square Presale Disclosure Requirements, Black Small Square Policy Disclosure, including minimum contractual terms, Black Small Square Policyholder Rights, Black Small Square Audit and Accounting Requirements, Black Small Square Investment Disclosure, Black Small Square Minimum Investment Standards, Black Small Square Corporate Governance of Segregated Funds, Black Small Square Partitioning of Assets Held in Segregated Funds, Black Small Square Closing of Segregated Funds, and Black Small Square Fundamental Changes to and Merger of Segregated Funds. Note, however, that segregated funds are also available through group annuity contracts. In that case, CIWM's Guideline G2 does not apply, and there is no guarantee for segregated funds purchased under a group annuity contract. 161. 2.6.6 Pension products and other group annuity products. Group annuity contracts are governed by the relevant insurance and income tax legislation, as well as by CLHIA's Guideline G12 entitled Capital Accumulation Plans. 162. Pension funds capitalized as group annuities contracts are not only governed by the relevant provincial or territorial insurance and income tax acts, and also by CLHIA's Guideline G12 for defined contribution plans, but also and primarily by the relevant Pension Benefits Act. 163. There is a pension regulator for each province, except Prince Edward Island, which does not have pension benefits legislation. For Yukon, Northwest Territories and Nunavut, as well as businesses that are within the legislative authority of the Parliament of Canada, the pension regulator is the Office of Superintendent of Financial Institutions, OSFI. 164. 161. C. 8. There are two principal types of pension benefits plans under the relevant pension legislation: defined benefit pension plans, DBPP, and defined contribution plans, DCPP. 2.6.6.1 Defined benefit pension plan, DBPP. A pension plan where the pensioner's entitlement is defined based on a formula in relation to income earned during the employment period and years of service, and not based on the financial performance of the plan. 2.6.6.2 Defined contribution pension plan, DCPP. A pension plan where benefits are payable and determined by members and or employer contributions and investment performance within the plan on those contributions. The employee typically can select the investment choices his funds are invested in from a range of options offered to plan members. 2.6.6.3 Pooled Registered Pension Plan, PRPP, 165. PPRPs are a new kind of proposed pension plan for individuals who are self-employed or do not have access to an employer-sponsored pension plan. The pooling of contributions for administration and investment by professional fund managers is intended to facilitate lower costs through economies of scale. To provide such pension plans to self-employed individuals, new legislation will need to be enacted in every jurisdiction. 2.7 Other products. Tax-free saving accounts, TFSA, registered retirement saving plans, RRSP, registered retirement income funds, RRIF, locked-in retirement accounts, LIRA, and life income funds, LIF, or products that can be offered through group or individual contracts. However, deferred profit sharing plans, DPSP, are group products. Listed below are specific products that agents may come across in the course of their practice. These products may involve an insurer as the provider, or they may involve insurance policies that serve as vehicles for investment, tax planning, succession planning, or retirement planning. Such products have been created by modifications to the Federal Income Tax Act, which have created tax incentives designed to encourage Canadians to save and prepare financially for retirement. Such products may be offered by insurers and are subject to specific legislation. 2.7.1 Deferred Profit Sharing Plan, DPSP, 166. A deferred profit sharing plan, DPSP, is a retirement savings vehicle that permits employers to distribute some of the company's profits to a plan for the benefit of some or all employees. Only the employer contributes, and the terms and conditions set by the employer can be very flexible. As with many other employer contributions to retirement plans, contributions vest after 2 years and can be recovered by employees when they leave employment and transferred to another DPSP, an RRSP, or another pension plan. When arranged through a life insurance company, it is set up through a group annuity contract. 2.7.2 Tax-free savings account, TFSA, 167. The federal and provincial government wants to assist citizens to save for their own needs, including retirement. There are limits to how much money can be deposited each year: $5,000 annually for 2009 to 2012, $5,500 in 2013, and 2014, $10,000 in 2015, $5,500 in 2016, 2017, and 2018, and $6,000 in 2019, but unused deposit room is carried forward, so lump sum catch-up deposits are possible. The deposits are not tax-deductible, but any income or growth earned in the account on qualified investments is not taxed as it grows, and withdrawals are also tax-free. Contribution to a spouse's plan is permitted, and recontribution to a plan is permitted after funds have been withdrawn. The holder of a tax-free savings account, TFSA, can also designate a beneficiary of the account upon their death. If the beneficiary is the married spouse of the deceased, or qualifies under the provincial law where they reside as a spouse, ownership of the account can be transferred to the survivor, and they are called a successor plan holder. They can also move the funds into their own TFSA. If the beneficiary is not a spouse, the funds are simply received as a distribution that bypasses the deceased plan holder's estate. When contracted through a life insurance company, it may be set up through a group or an individual annuity contract. 2.7.3 Registered Retirement Savings Plans, RRSP. Registered Retirement Savings Plans, RRSP, have flexibility for unrestricted withdrawal at any time, subject to withholding tax which may require increases with the amount withdrawn. Recontribution is not permitted. 2.7. For Registered Retirement Income Fund, RRIF. A Registered Retirement Income Fund, RRIF, can be described as a retirement income payout plan with the greatest opportunity for income deferral through minimized withdrawals. No withdrawals necessary until age 71. Also provides the most flexibility for maximum, unrestricted withdrawals, again subject to withholding tax. 2.7.5 Locked-in Retirement Account, LIRA. A locked-in retirement account, LIRA, is another type of registered retirement savings plan containing funds transferred from a pension plan. Plan holders are generally unable to withdraw any amounts before age 55. Locking in then limits any withdrawals so that the plan can be expected to provide a predictable but not guaranteed income until age 90. From a tax point of view, a LIRA is a RRSP, for which additional rules flowing from pension benefits legislation apply. 2.7.6 Life Income Fund, LIF. A life income fund, LIF, is a type of retirement plan investors may transfer their pension into if they leave a pension plan. Minimum and maximum income amounts each year in retirement are subject to the pension laws of the province that apply to the LIF and the amounts in the plan. From a tax point of view, a LIF is a RRIF, for which additional rules flowing from pension benefits legislation apply. Chapter 3, Life Insurance, Accident and Sickness Insurance and Annuity Claims Payment of Proceeds. Competency Component Black Small Square Integrate into practice the legal aspects of insurance and annuity contracts. Competency Subcomponents Black Small Square Integrate into practice the rules relating to beneficiary designation and exemption from seizure of benefits. Black Small Square Contextualize the rules relating to claims and the payment of benefits. Ethics and Professional Practice Chapter 3 Life Insurance, Accident and Sickness Insurance and Annuity Claims Payment of Proceeds 80.